Namaste everyone. My name is Tanya, and today I will be speaking about the infamous Rangila Rasool case of the 1920s in undivided India and how it gave birth to IPC Section 295A, which is also known as the Indian variant of a blasphemy law. And we'll also analyze its past, the present, and its future possibilities and how exactly we should see it going in the future. So I'll quickly move to my presentation. So as the title goes, the Rangila Rasool case and the birth of IPC Section 295A, the Indian variant of blasphemy law. That is my speaker intro. I published a few white papers and reports for the perusal of state governments on behalf of a policy research organization. I've been a historical researcher, worked with some renowned names and organizations involved in Indian research. I've worked with NGOs as a strategic advisor. I teach master's degree student at a university, and I'm associated with Sangam Talks as an editor and researcher. I also run a successful blog that deals with politics and has been recommended by many national and international academic publications and universities, as well as many other noted figures in the domain. I've worked with corporates like Times of India and Wipro, etc. And I also write on online platforms like Creately, Medium, and Indic Tales with topics relating to politics, history, and policy, etc. Now, before we go into the topic of Rangila Rasool, it's very important to understand Middle Eastern coloniality, because that is exactly from where this whole, division and this whole, schism that had come about in society originated, and how they dealt with the common subjects. That's very important to understand. So, and these bullet points have been taken from Dr. Meenakshi Jain's short speech during the book launch of J. Sai Deepak's latest book, that is India, Bharat, and Pakistan. So she mentions in a speech that the Delhi Sultanate, established in 1206, had its entire cabinet consisting only of around 40 Turks. So no Indians there. The Khalji dynasty continued the same system with a new batch of Muslims imported from Khalaj in Afghanistan. And during the period of the Saids, about 22 Afghan families shared all political posts themselves. Babur brought with him two groups of people, the Iranis from Iran and the Duranis from Central Asia, who constituted his entire political system. The same was continued by Jahangir upon return from his exile. Akbar had a 70-30% administration, where foreign-born Muslims were 70% and Hindus and Indian Muslims were 30%. This continued during the reign of Aurangzeb as well. Mughal period architectural rule was that every lane, by-lane, and highway should be dominated only by mosques and Islamic monuments. Also, as history shows us, that no Mughal emperor ever acknowledged their Rajput blood or felt proud of it. To say that there was a Ganga Jamuni syncretism or tehzeeb is to ignore what a contested memory we have had as Indians of the Mughal period. And Shah Jahan and not Akbar removed the pilgrimage tax upon the request of an influential Sanskrit scholar named Kavindra Acharya. And Hinduism and Islam are two contrasting worldviews and thought traditions that have existed side by side throughout the medieval period. And I, who is Dr. Meenakshi Jain, she says that I have found no evidence of them ever meeting each other. So that is Middle Eastern coloniality. Now we move on to common, citizens' relations and areas of conflict between 1200 to 1500 CE. The period 1000 to 1850 is found dotted with Hindu-Muslim conflicts. And the source of this is the pre-colonial ethnic violence, the case of Hindu-Muslim conflict in India by Ajay Varghese, Robert Stephen, and Foa. And then in the 14th century, the famed Moroccan scholar Ibn Battuta wrote about the state of Hindu-Muslim relations in South Indian town of Mangalore. War frequently breaks out between them and the Hindu inhabitants of the town. But the Sultan, the Hindu king, keeps them at peace because he needs the merchant. And this is also sourced from the author Ajay Verghese from the Berkeley Center, Georgetown University. So evidence states, and this is this bullet point comes from David Lorenzen's book, which is Who Invented Hinduism, and he states that the period between 1200 to 1500 CE was a time in which rivalry between Hindu and Muslim created a newly self-conscious identity of the Hindu or proto-Hindu unity. And then there's also one more text known as Kirti Lata. It is a text written by a poet Vidyapati in the early 15th century, around 100 years before Kabir began writing. And the hero of this romance, Prince Kirti Simha, while passing through the city of Jaunapur, which is modern Jaunpur, describes the Muslim quarter of the city and writes, the Hindus and the Turks live close together. One makes fun of the other's religion. Some practice namaz, others do puja. The Turks coerce passers-by into doing forced labor. Grabbing hold of a Brahmin boy, they put a cow's vagina on his head. They rub out his tilak and break his sacred thread. They destroy temples and construct mosques. So now we move on to Sant Eknath, who lived in the 16th century between 1533 to 1599. And he wrote the Hindu-Turk Samvad. The Muslim mocks the Hindu faith by alleging that Brahma got attracted to his own daughter, Saraswati, took away Ram's wife, so monkeys came to help him. Krishna was imprisoned. What kind of God is he? Your Shastras, Vedas, Om, all are evil tricks, you stupid idol worshippers. And the Hindu monk only responds with, why don't you accept that God is everywhere and in everyone and in idols, not just in Mecca? Why do you kill animals and always want to convert Hindus? Is being born Hindu a sin? I've listed the source at the bottom, David Lorenzen's Who Invented Hinduism. Now we move a little forward to the 1800s and we come to a very important conflict that has been one of the first that has been recorded in colonial India in 1809. And this was the time before the English laws, that is the IPC and other such penal laws penal provisions came into existence. And at that time we had the PITS Act, the Regulating Act, and these were mostly dealing with economic issues and also with certain public order and other such kind of things that were happening in between, but nothing to deal specifically of religious issues. So this is the Lat Bhairav riots of 1809, and the Lat Bhairav temple is there in Banaras. It's between the temple of Vishwanath and the Eidgah, that is there, the mosque. And so it is at a very, very sensitive place. And so the Lat is basically a kind of a pillar, in fact, a stump now, that is believed to have been associated with the, Puranic stories and the legend of Kal Bhairav and the whole fracas that happened with Brahma when his head was severed. And, the whole story is, of course, known to everybody. So the Lat Bhairav, this pillar, is known to be the staff of Kal Bhairav, and through which punishment is meted out to sinners. And so that is the importance of the Lat Bhairav temple, and you can read it up on the internet. It's given in great detail. So the Lat Bhairav is married off to a nearby well, and this is done every year as per tradition. So in 1809 in Banaras, now one has to understand the the religious scape here, and the kind of what kind of religions were prevailing at that time in Banaras. So the lower class weavers that were there, they were of course neo converts through the whole kind of belief system in Ghazi Mia, who was the nephew of Mahmud of Ghazni, and his name was Salar Masood. And he was also a military general in Ghazni's, army, and he was known to be a proselytizing Muslim, and he was killed in battle by one of the Hindu kings, Suhail Dev. And all these accounts come through hagiographies of Qazi Mian Salar Masood by Muslim, hagiographers. So this Lat was at one point in time a common sacred space for both the lower class Hindu as well as Muslim weavers. And the Hindu merchants were the ones who were in charge of the business being given to the weavers. So coming to the 1809 Lat Bhairav riots of Banaras. So before the Lat Bhairav marriage festival, the Muslims, after their Friday prayers, raised a protest. And according to the Muslim memorial, it states that the idols of Sri Ram and Master placed in the pulpit in the premises of the Eidgah. And according to the Hindu memorial, the causes were different. Since there was no such law put in place with regard to religious spaces, and there was kind of a status quo, and the British maintained a kind of a, non-interference stance. And so there was constant disputes that were happening in the past as well, where idols were kept at the people tree near the Lat Bhairav pillar, and the aarti was done and they were prayed to. And then when the Muslims came to the Eidgah to pray on Eid and other major festivals on Fridays, the idols were quickly removed or covered up. And so this was continuing since a long time. And so the Qazi there, who was the law officer, and the Kotwal was in charge of the police, and he was responsible to the Mughal. And of course, the British were in charge of revenue collection, etc. And so this is how the whole, administrative setup functioned there. So this time, normally the Qazi was complained to after the Dashera festival and Lat Bhairav marriage festival was over. So this time after, these are well recorded, historical documents in the Hindu and Muslim memorials that are, in the archives, which were recorded by the Britishers and kept as records in this case. So in the 1809 Lat Bhairav riots in Banaras, colonial Banaras, the Lat Bhairav marriage festival, the Muslims, after their Friday prayers, raised a protest and polluted the area surrounding the Lat Bhairav, and also beat it with shoes, etc., among other sacrilegious acts at night. And the Hindu memorial states that there was a small Hanuman idol that was placed kind of a space or chabutra between the temple and the Eidgah. And there was a Hindu businessman who had recovered from a grave illness and wanted to build a small shrine there dedicated to Lord Hanuman. And this land was not claimed by anyone, this space. And so it was something that was unclaimed. And so this kind of aggravated the other community. And while they were polluting the surrounding areas of Lat Bhairav and doing all these sacrilegious acts, they also overturned the Hanuman idol that was placed on the pedestal. And all this was done. And next morning, the Hindus gathered in large numbers at the site of sacrilege. And the situation became out of control, and the Kotwal had to arrive on the scene with a large contingent in order to disperse them. It was later known, according to the Hindu memorials, that the Kotwal, a Muslim, was found to have gotten hand in glove with his community as per the Hindu memorial of the riots. And he had seated himself at the foot of Lat Bhairav and invited the Hindu representatives to appear before him to air their grievances. Upon complying, Ratan Singh and his 3 associates were simply taken to the police station where they were beaten without any inquiry. And this led to all the more retaliation from the Hindu community, especially the Rajputs and the Gusains, who were religious mendicants and mercenary traders. And of course, the Hindu community was more than the Muslims, so they outnumbered the Muslims. And this mostly comprised of the weaver class of the Muslims, the neo-converts. But due to the diplomacy and firmness of the district magistrate, the rioters were eventually broken up and the city was completely in the power of a large military force by the third day. Now, by the law as then existing, the sentences passed on the offenders should have depended on the fatwa or legal decision of the Muhammadan law officers, who would, however, have been obliged to release the Hindu prisoners in order to avoid meting out the same punishment to the Muslim detainees. And so the Muslim memorial ends with nothing but an appeal for separation of the two communities and the religious spaces. The acting British magistrate, Mr. Bird, protested against this, and he writes that although common sense and natural justice must view the excesses of both parties as equal offenses against the public peace, authority of government, and the welfare of the society, still the fundamental principles of the Muslim law are diametrically at variance with such a sentiment. That law, resting on the assumption of excessive sanctity of the Mohammedan religion and the heresy of all other modes of belief, will consider the slightest insult offered by a Hindu to a place of Muslim worship as heinous sacrilege and profanation, while in the greatest outrage committed against any object of Hindu superstition, it will see nothing but a laudable attempt at the extirpation of idolatry. So the government eventually dispensed with the fatwa and instead decided to have the trials conducted by a special court appointed by the government. And it was decided that whatever was made to the original position of the parties, no alteration would be done. And permission was given to both the parties to repay damages according to their respective religious customs, and each purified their violated altars. But it was not until June 1810 when the Hindus reconsecrated their outraged shrines and veneration was paid to the original pillar. And so the first riot can be said to have actually concluded in June 1810, about 7 to 8 months after the riots. And the source of this is the Hindu-Muslim relations in colonial Banaras from the Lat Bhairo riots of 1809 by Sundar Vishuvalingam with the collaboration of Elizabeth Shalia Vishuvalingam. And we see a rehash of this entire episode recently in 2016. Again, the center of focus was the Lat Bhairo temple, and there was riots that had happened there in the same manner and almost like history repeating itself. I've given the link to the article. One can read it. Now we move a little further. So there were Parsi Muslim riots that happened in the first week of October 1851, which took place over the blurred depiction of the Islamic prophet Muhammad, and in a Parsi newspaper known as Chitra Gyan Darpan. Then a second riot took place in May 1857 over a Parsi named Bejonji Shariaji Barucha was accused of disrespecting a mosque by some Muslims. And then a third riot took place on 13 February 1874 over an article on the life of Prophet Muhammad in a book entitled Famous Prophet and made to occur in Tamil Nadu in and the origin is to be the origin of the Hindus to a construction of the mosque by the Muslims in Salem, which was also a path through which the Hindus carried out religious processions. And so riots followed for around 3 days. And the British government basically couldn't do anything for 3 days, but ultimately the mosque was pulled down and there was indiscriminate killing on both sides. And then eventually there was a kind of a equilibrium that was achieved, and a lot of people were arrested and speedily convicted and given harsh imprisonment. Now we move a little further to 1897 in Jhelum city. So Jhelum city currently is in Pakistan. So Pandit Lekh Ram was an active writer and publicist, and he was the founder of the Arya Samaj branch in Peshawar. And he was known to be active in bringing back converted Muslims to Hinduism through his debates and discussions. And he was known particularly for his encounters with Mirza Ghulam Ahmad, the founder of the Ahmadiyya movement. When Ahmad published the Surma-e-Chashma Arya, an antimony to open the eyes of the Aryas, Lake Ram uh, retaliated back by writing the Nuskha-e-Khabt-e-Ahmadiyya, a prescription for the madness of the Ahmadiyya. Then again, there were some back and forth publications. And in 1892, Lake Ram published his controversial treatise, Risala-e-Jihad Yani Deen-e Muhammad Ki Bunyad, a treatise on holy war or basis of the Muhammadan religion. And so it accused Islam of being a warlike and sensual faith. And this escalated the already existing communal tensions between Hindus and Muslims in the early 1890s. So amid these polemical exchanges, Mirza Ghulam Ahmad published an announcement in 1893 in which he prophesied Lake Ram facing divine punishment and dying in violent circumstances within 6 years. And this will be very close to the Muslim festival of Eid. And then, so 4 years later, on March 6, 1897, the day following Eid, Lake Ram was stabbed to death while staying in Lahore by a Muslim who was a stranger to the city but had been staying with Lake Ram for 3 weeks under the pretext of wishing to become a Hindu. The police investigation failed to apprehend the assassin, and Ahmad maintained that he had no hand in the fulfillment of the prophecy. And although he was suspected by some, but nothing could be proven. I've given the source for the same. Then, apart from Lake Ram, there are a few other precursors to Rangila Rasool case and the murder of the author and the murder of the editor, Mahashay Rajpal. So Swami Shraddhanand of Arya Samaj was shot by Abdul Rashid on 23rd December 1926 when he was lying in his sick bed. And this was followed by the murder of Lala Nanak Chand, a prominent Arya Samajist of Delhi. And this is, of course, a very short list and could be easily expanded if you look up the internet. Then, along with all these conflicts that were happening on religious lines and communal lines, one should also take note of the political developments that were happening at that time. The British, who had burnt their fingers with 1857 and 1809, the Banaras riots and many such things, and there was an open kind of agreement in the British administration and the kind of officers that they have to follow the divide and rule policy if they had to govern this country and kind of maintain their stronghold in it. And so seeing the Congress catching up quickly to them and gaining a kind of a stronghold, the Viceroy Minto, they kind of sat together, Morley and Minto, and they were looking for ways to kind of prevent the Muslims from joining the Congress and, kind of getting the whole Congress strengthened. So, in pursuance of this, on 26 July 1906, Morley made a speech in the House of Commons in which he hinted at reforms in the Indian legislative councils. And a few days later, on 4th August, the Secretary of Aligarh College, Nawab Mehdi Ali Khan, better known as Mohsin ul Mulk, wrote a letter to Archbold, the British principal of the college, who was at the time spending his summer vacation in Shimla. And in it, he asked whether it was advisable for a delegation of Muslims to meet Viceroy Minto in order to speak to him about the rights of Muslims in India. So the British, of course, had an idea that the Muslims were not very active or very participative and not very keen about this whole freedom movement that was being carried out by the Congress and under the leadership of Gandhi. And this was made known through the writings of many famous Muslim, political figures, influential figures at that time. One of them being Sir Syed Ahmad Khan, the founder of Aligarh Muslim University. And he was one of the first proponents of the two-nation theory. And in his writings, he constantly wrote about how Hindus and Muslims were two antagonistic races who can never reconcile. And also, he termed the 1857 War of Independence as an act of bastardliness and pledged his alliance to the British instead of the Hindu dominated Congress and urged all fellow Muslims to do so through all influence under his command. So the Muslim delegation then met Viceroy Minto at Shimla, and they proposed that Muslims be given weightage in legislative councils because the Muslim community was politically important. It contributed to the defense of the British Empire, and the Muslims were, before the British arrived, the ruling race in India. Dunlop Smith wrote a letter back to the British the following day in which he said that the Muslims declared to the Viceroy that they would not join the Congress and that they preferred appealing to their Ma-Bap, and the Muslim League itself was founded. 90 days after this deputation met Minto, though Muslim opposition to the Congress was decades old, spearheaded by Sir Syed Ahmad Khan, as already mentioned. Then we move a little further. The Muslim electorates are given. The Morley Minto reforms are passed in 1909. And now we move to the Khilafat movement in 1919. So the Mohammedans, under the leadership of the Ali brothers, Muhammad Ali and Shaukat Ali, started the Khilafat or the Caliphate movement in 1919. It is well known that it was to, replace or bring back the Caliphate, the Caliph of the Ottoman Empire in Turkey. And since this was also directed at the British, so Gandhi tried to align it with his non-cooperation cum Swaraj movement to get the Muslims into the freedom movement, since his last satyagraha against the Rowlatt Act had failed in early 1919. But within a year of starting this Khilafat plus non-cooperation Swaraj movement, the Muslims had grown impatient. And the Muslims in their impatience did exactly what the Hindus feared they would do, namely invite the Afghans to invade India. And how far they were successful in their negotiations with the army of Afghanistan is not possible to know. But that such a project was even entertained is, a very dangerous thing, and every sane Indian would disassociate himself from so mad a project. Because the methods adopted by the invaders have left behind them their aftermath. One aftermath is the bitterness between the Hindus and the Muslims, which they have caused. And this bitterness between the two is so deep-seated that a century in political life has neither succeeded in assuaging it nor in making people forget it. And this is from the book Pakistan or Partition of India by Dr. B.R. Ambedkar. Now, one has to take note of Gandhi's unawareness about this historical strife in Hindu-Muslim relations. And he writes in Young India, which was published between 1919 and 1931, thanks to the advent of the printing press. And there was a lot of things going on at that time. A lot of things were being printed and published, including all the pamphlets that we just mentioned in the previous slides. So the Hindus and Muslims lived at peace among themselves during the Mughal rule. It is my belief that had there been no Muslim rule in India, even then there would have been Muslims in India. In those days, they were not known to quarrel at all with each other. There is nothing to prove opposite to this. The enmity cannot last for long. They are brothers and must remain so in spite of temporary insanity. These are Gandhi's writings in Young India. Islam throughout history has stood for matchless bravery and peace. And then after the Mopla riots, Gandhi writes, unity is like marriage. It is more necessary for a husband to draw closer to his wife when she is about to fall. Then is the time for double outpouring of love. Even so, it is more necessary for a Hindu to love the Mopla and the Muslim more when the latter is likely to injure him or has already injured him. Then the next is Vande Mataram and Jai Bharat frighten the Muslims today. I am glad that Shahid Sahib suggested the revival of Khilafat slogan, Hindu Muslim ki Jai. Then the next is the cry Allahu Akbar terrifies the Hindu, but there is nobility in its meaning. It means God only is great. If therefore there is to be a lasting friendship between the two, the Hindus should have no hesitation in uttering the cry together with Muslim friends. God is known by many names. The Ram Dhun has the same virtue. And the next is the science of surrender. The Hindus will have to bear the sight of cow slaughter, and the Muslims will have to discover that it was against Islam to kill a cow just to incense the Hindus. These are just a few of Gandhi's writings. You can read some more. It is available online on archive.org, and it is very easily available to read. Now, some people had very clearly made their, displeasure and their fears public of the Khilafat movement and Gandhi's, unconditional support, leading to more kind of fanaticism in the Muslim, community and their leaders, and that religion itself will, kind of take them forward. And this was openly made public by Annie Besant and Sarojini Naidu and many other prominent voices against this whole, encouragement on religious lines. And it has been mentioned very clearly in public records. So Patrick McGuinn, in his book, you can see Communalism and Northwest Frontier Province. At the bottom, I've given the link. So Patrick McGuinn writes, the heightened sense of religious identity which existed among the Muslim community was accentuated during the Khilafat movement, and the Orthodox ulama had been brought into political activity on a large scale. He adds that the activities of the ulama in the years following Khilafat can be seen as an effort to perpetuate power and influence within the Muslim community. Communal issues became more important at the local level now, and those Muslim leaders who had been heavily involved in the Khilafat movement became the defenders of the faith in subsequent years. While Gandhi piggybacked on the Khilafat movement to artificially forge a Hindu-Muslim unity, the underlying religious antagonism did not remain concealed for long. And in fact, Annie Besant blamed the whole Mughal, riots on Gandhi's this very fault of, encouragement in the form of combining the Khilafat, which was a religious movement, and the Swaraj or the non-cooperation movement. Now we come to the moot point, which is the Rangila Rasool case. And of course, the publications Vichitra Jeevan and Sair-e-Dozak, which was published in the journal Risale Vartaman. So these three works, Vichitra Jeevan by Pandit Kali Charan Sharma in 1923, the book Rangila Rasool by Pandit Chamupati 1924 and published by Mahashay Rajpal, and an article titled Sair-e-Dozak by Devi Sharan Sharma in the monthly Risala-e-Vartaman 7, at the core of the issue. And all of these authors and publishers were Arya Samajists. So what was the point of origin of these, conflicts and these riots? It began in 1923 when the Muslim community published three particularly offensive books to the Hindus. Krishna Teri Gita Jalani Padegi, which used derogatory and vulgar language against Sri Krishna and other Hindu deities. And then there was Uniswi Sadika Lampat Maharishi, which contained derogatory remarks on Arya Samaj founder Swami Dayanand Saraswati. And this was written by an Ahmadiyya. And then there was another text which contained obscene and appalling sketches of Hindu deities and sickening abuse and vile character assassination of Ma Sita, who was also termed as a libertine. So in response to this provocation, Pandit Chamupati Lal, a close friend of Mahashay Rajpal, wrote a short biography of the Islamic prophet Muhammad, and the short biography was published in the form of a book titled Rangila Rasool. This short pamphlet was a satirical take on the domestic life of Prophet Muhammad, and it was published via Rajpal's publishing house. Now, this was first published in May 1924, this pamphlet, and it quickly sold its first edition of 1,000 copies. And Gandhi then supposedly received a copy of it from his friend, and he complains about this in Young India, and also, puts allegations on the intentions of the publisher and the author, and makes a case basically in his writing that this is meant to inflame the already communal tensions and the religious passions of the Muslim community. So he writes that a friend has sent me a pamphlet called Rangila Rasool, written in Urdu. The author's name is not given. It is published by the manager Arya Pustakalaya, Lahore. The very title is highly offensive and the contents are in keeping with the title. I cannot, without giving offense to the reader's sense of the fine, give the translation of some of the extracts. I have asked myself what the motive possibly could be in writing or printing such a book except to inflame passions. Abuse and caricature of the Prophet cannot wean a Muslim from his faith, and it can do no good to a Hindu who may have doubts about his own belief. As a contribution, therefore, to the religious propaganda work, it has no value whatsoever. The harm it can do is obvious. So there was a subtle hint given to the kind of, religious rights that could erupt, according to Gandhi, by inflamed passions of the Muslim community after reading this book. With these words, Gandhi immediately raised the question of motive in the publication of such literature, and it came to public notice. Orders had been put in for a second edition in late June for the pamphlet when word came of a ban and prosecution under Section 153A of the Indian Penal Code, year after IPC. So then Rajpal was arrested in around June-July 1924, and he held that the agitation on which the prosecution had commenced proceedings was artificial, unreal, and wholly engineered, and a result of the above quoted article by Gandhi in Young India, and not the publication or the pamphlet itself. In his statement before the court of C.H. Disney, the magistrate first class Lahore, the accused Mahashay Rajpal, the publisher of the pamphlet, announced that he had been motivated by a desire for social reform to wean and deter people from the evils of polygamy, concubinage, muta marriages, and gross disparity of age in marriage between the two communities, from the pamphlet's discussion of such practices in the life of the Prophet Muhammad. He held that such discussions were a necessary condition of civilized existence, particularly so in British India, where on account of the perpetual conflict of creeds and zeal for proselytization, the toleration of religious criticism has been recognized as an essential principle of criminal law. After invoking the works of European authors on the life of the Prophet and claiming that the pamphlet relied on facts, Rajpal held that the descriptions were elegance and moderation itself, and that the sober, restrained, and dignified. In short, he had no cause to repent and had not the slightest intention of promoting or attempting to promote feelings of enmity or hatred between different classes of His Majesty's subjects by this publication. And this whole charge of 153A of the IPC was that anyone who by intention of promoting or attempting to promote feelings of enmity or hatred between the different classes of His Majesty's subjects was bound to be punished. And so that was what 153A of the IPC was all about. The court, however, rejected his defense in the nature of truth, which he claimed that his defense was truth and social reform. And these were, conditions that were there in the IPC section 499. Now, while this trial was going on in 1924, you see that in September 1924, in fact, 1924 onwards, right till the 1930s, there were riots, a series of riots that kind of had a cascading effect. And one of these very initial riots in 1924, while the Rangila Rasool case trial was going on, in Kohat, which was a Hindu minority area, a highly objectionable and blasphemous poem was published in May 1924 by a notorious Muslim-centric newspaper named Lahore, which read that we shall have to burn the Gita of Kirars. We shall break the flute of Krishna. O Muslims, you will have to take up the sword and destroy the existence of Kirars and burn their goddesses. So there, the local secretary of the Sanatan Dharma Sabha, Jivan Das, then in retaliation printed a poem by an author from Jammu, which read, "We have kept quiet so long, we shall have to speak out. O Mullah, you must gather up your prayer carpet and take it to Arabia. We shall build a temple to Vishnu in place of Kaaba and destroy the existence of the Namazis." Now, several contemporary Hindu writers who knew the fact stated that the local Muslims were very fond of abducting Hindu women, married as well as unmarried, and converting them to Islam through fear of sword. And Jivan Das's booklet contained strong strictures against such a barbarous practice. And this was brought to the notice of Gandhi, who, however, pushed it aside in his Young India writings and said that it is not possible for anybody to kidnap somebody and convert them into Islam and so on and so forth. And so the source for this paragraph is Muslim Appeasement by V. Sundaram. Then, following this publication, inflammatory speeches were made by Muslim leaders in mosques. On September 3, 1924, Maulvi Ahmad Gul and Qazi Miraj Deen led a Muslim crowd to the Assistant Commissioner of Police's office, S. Ahmad Khan, and demanded action against Jivan Das, or else they would take action as per Shariat. Shariat law, it definitely says that any offense committed against the Prophet is to be met with death. And so that was the Sharia law. And so they threatened that if the police doesn't take any action against Jivan Das, they would take action as per the Sharia law. And Maulvi Ahmad Gul and Qazi Miraj Deen received support from other clerics as well, such as Shaheen Shah and Mia Fazul Shah. Khan assured them that Jivan Das would be prosecuted under 505 and 153A. And then a few days later, on September 8, Jivan Das was released on bail and asked to leave the district until the conclusion of the trial, for, of course, fear of his life, because they had made very clear that they wanted to punish him according to Sharia, which was an extra legal and extrajudicial kind of punishment that they wanted to enact. The ulemas held large meetings and convinced the Muslims of Kohat that Das had been let off. At Haji Bahadur Mosque, fanatic Muslims took the oath of talaq, that if they couldn't defend their religion, they would divorce their wives. And on September 9, 1924, a crowd of about 1,500 Muslims first went to meet the Deputy Commissioner Riley and forced him to give in to their demands. And for 2 days, what followed was uncontrolled arson, loot, and murder by the Muslims at the Hindu Mohallas, followed by exodus of entire Hindu and Sikh community. Casualties of Hindus was 3 times more than Muslims, and it took a week to douse the fire by the British police force. I've given the source at the bottom. Now, as I mentioned, that there was a series of riots from 1924 onwards, and this is mentioned in B.R. Ambedkar's book, Pakistan or the Partition of India, in chapter 7. So 1924-25, there were riots at Lahore, Lucknow, Muradabad, Bhagalpur, Nagpur, Shahjahanpur, Kankinara, Allahabad. 1925 to 26 also we see Calcutta, United Provinces, Central Provinces, Bombay Presidency, and the scene was some minor Hindu festivals were celebrated and the Muslims objected, and then there were riots. 1926 and 27 also you see communal riots happening. This continues to 27 to 28, and this is which has been noted, and these all had kind of similar origins and similar consequences. Now, coming back to the Rangila Rasool case trial, which was carrying on for 2 years till 1926-27. For over 2 years, the case dragged through the trial court of the district magistrate, then the sessions judge, and finally the Punjab High Court. In the first 2 courts, Rajpal was found guilty of creating enmity between classes, and pamphlet was held to be intentionally offensive, undoubtedly malicious in tone and intention. The sessions judge makes a special mention also that the offense is dangerous and reprehensible. Therefore, It is necessary to both punish and deter others from repeating such acts. In short, to make an example of Mahashay Rajpal. Mahashay Rajpal then appeals to the Lahore High Court and Justice Dalip Singh. And Justice Dalip Singh quoted the above extract from the ruling of the sessions judge and added that although the pamphlet was undoubtedly nothing more or less than a scurrilous satire on the founder of the Muslim religion, but he could not find anything in it that showed it was meant to attack the Mohammedan religion as a whole or to hold up Mohammedans of today as objects worthy of enmity or hatred. Dalip Singh felt that the subject of a malicious satire on the personal life of a religious teacher was outside the purview of Section 153A. So, in a judgment that would be quoted in Press and Pulpit, he said that it seems to me that the section was intended to prevent persons from making attacks on a particular community as it exists at the present time and was not meant to stop polemics against deceased religious leaders, however scurrilous and in bad taste such attacks might be. For instance, if the fact that Muslims resent attacks on their Prophet was to be a measure of whether 153A applied or not, then an historical work in which the life of the Prophet was considered and judgment passed on the character of a serious historian by a serious historian might come within the definition of Section 153A. I am unable to hold that Section 153A was meant or was intended to prevent all adverse discussions of the life and character of a deceased religious leaders. And so here you can see that a fine line is drawn by the judge on what exactly the law held out 153A, and it was not in the purview 153A to judge this case, and so kind of there was IPC was deficient in this, and as per what was given to him, he sees that there is nothing that he can do under the current section of 153A, which doesn't deal with any historical or any academic study of religious persons in history, and so therefore he states that there should be another law that is made for these kind of pamphlets, bazaar pamphlets printed by scurrilous people, published with the intention of wounding the religious feelings of any person or insulting the religion of any person can be made criminal. But 153A was not having under its purview to, take into account this satire on the life of the Prophet. And he also warned against this becoming a norm if there is some academic study or any historical account and based on facts and truth, which might be hurtful to a certain community about their founder or anything, but that also should be taken care of, as opposed to scurrilous pamphlets that are printed out of the blue by the bazaar elements or the printing press, which is done out of malicious intent or whims and fancies. So there should be a clear distinction made between academic study, historical study, and the conclusions, and between these, and it should be dealt with accordingly. Justice Dalip Singh conceded that the pamphlet in question could only arouse the contempt of all decent persons of whatever community. The justice did not think that it would necessarily promote feelings of enmity and hatred between different classes of His Majesty's subjects. That might be the result, but it could not be made the test of the section. So he makes a very clear distinction between the law being applied on the nature of the offense and the content, rather than applying the law on the basis of a hypothetical situation or a probability or the consequence or the result of any such a document or writing or a discussion. So the consequence cannot determine the law and its application. The content and the section itself should be found to have been fulfilled, and then a punishment accordingly needed to be meted out as per the law. So that is a very clean and neat judgment taken out by Justice Dalip Singh. And in conclusion, Dalip Singh, however, recommended the addition of a clause to Section 297 of the IPC by which pamphlets published with the intention of wounding the religious feelings of any person or of insulting the religion of any person might be made criminal. Rajpal was admittedly reluctantly acquitted, and soon after, in several places, riots broke out after provocative speeches were given by religious leaders. Al Jamiyat, an official arm of the Jamiat Ulema-e-Hind, warned in an article that under Sharia, the punishment for insulting the Prophet is death, and it is legally permissible according to Islam to kill those who insult the Prophet. Maulana Muhammad Ali of the Khilafat movement, once held up by Mohandas Gandhi as a great ambassador of Hindu-Muslim unity, in a provocative speech at the Jama Masjid in July 1927, predicted that very serious consequences would follow the acquittal should the judgment not be reversed. Muslims would be compelled to take the law in their own hands. And then the Muslim Outlook published a review of the judgment and took a particularly strong position recommending that an inquiry be conducted into the circumstances under which Justice Dalip Singh wrote his judgment, considering he is a Hindu, and also that the judge, now damned as incompetent, should resign. Now, it is very important to note, and it is very interesting to note, of course, the Muslim press, the Mumbai Mirror was clearly, Muslim Outlook was clearly, against his judgment. And in their publications, Muslim Outlook, they accused Justice Dalip Singh of siding with the Hindus because he was a Hindu himself and therefore he was incompetent and should resign. But what is interesting to note is with the riots breaking out and all these law and order situations erupting in different parts of the country, the British governor of that undivided Punjab, Haidy's response to the judgment of Dalip Singh. It was the intervention of the British government at this juncture that reinforced the sense of wrong felt by the Muslim community at large. For the first time, an executive of the state had spoken out in public against the judgment of a high court. And Haidy also emphasized the balance between freedom of expression and public order that the government claimed to want to manage, a balance that resonates with the purported raison d'etre of the post-colonial government of India. He says that if we have obligations for the preservation of public tranquility, we are also bound to respect the claim for that freedom of discussion which is necessary for the ascertainment of truth, historical or religious. A serious and critical treatment does not entirely exclude the use of satire, but it would certainly stop short at deliberate ridicule. Much, therefore, will be found to depend on the manner of treatment and much on the intention of the writer. So a deputation of leading Muslims called upon the Punjab Governor Malcolm Haidy to protest against the High Court ruling of Justice Dalip Singh. The governor's response, widely published and commented upon, seemed to give a free pass to subsequent Muslim expressions of anger, as it sympathized with those Muslims who felt justifiably offended by the pamphlet and felt that they had no legal weapon by which its repetition could be prevented in the future. And as we all know, the British was continuing its policy of appeasement to all communities, and then also the divide and rule, which was happening simultaneously. So they were wanting to play safe on both sides. So Haidy maintained a kind of a, here and there kind of thing where he did not ask Justice Dalip Singh to resign either, and neither did he, he just sympathized with the Muslim community. And so then he just took a back seat from there. And he admitted that the judgment had left the government much concerned, for if this type of religious controversy could be carried on with impunity, there lay a vista of endless struggle before the public. And he also stated that the government had consulted legal advisors on the appropriateness of undertaking a modification of the law, as Dalip Singh had suggested, the adding of, and something to the 297 to deal with such issues. However, to begin with, the government was hoping another test case would verify whether or not such attacks fell under the purview of Section 153A. And so now Governor Haley and the British government were looking for such more similar cases where they can hope to overturn the judgment of Justice Dalip Singh to placate the Muslims and do it through judicial means and legal means so that the Hindus also don't feel offended. And it seems to be done, in a neutral manner. So this was the kind of strategy he adopted. And those test cases where they could overturn the judgment of Justice Dalip Singh and make it not stand the test of time. Those test cases came in the form of trials on the publications Vichitra Jeevan and the article Sair-e-Dozakh in the journal Risala-e-Vardaman. Now, what are these two cases? So, Vichitra Jeevan was, of course, published a year before Rangila Rasool, but it did not come to the attention of the government till the trial of Rangila Rasool, for obvious reasons, because they were looking for test cases to overturn the Justice Dalip Singh judgment. So on 24th February 1927, the full bench of Allahabad High Court convicted the accused of the author of Vichitra Jeevan, Kali Charan Sharma, for the offense under Section 153A for writing a blasphemous book entitled Vichitra Jeevan, which was in retaliation to some scurrilous writings on Hinduism by the Muslim community. So as soon as the article, which was Sair-e-Dozakh, was published in 1927, May 1927, in the journal Risala-e-Vardaman, Hazrat Mirza Bashiruddin Mahmud Ahmad Khalifatul Masih wrote an article urging all Muslims who claim to love the holy prophet of Islam to come forward and voice their injured feelings so as to be heard by the official authorities. And the article titled Kareem ki mohabbat ke dawa karne wale kya ab bhi bedar na honge was printed in poster form and exhibited all over India. And the outcome of this poster was recorded by All India Reporter, Lahore, 1927. Had it not been for the part played by the Mirza of Qadian in sending a poster to Amritsar, the article of Risala-e-Vardaman may not have been seen as highly inflammatory by the law enforcement agencies. The Arya Samajist circles pressurized to remove the poster, as it was also highly inflammatory towards their community. And it was proscribed by the police, but it had already served its purpose of awakening the Muslims. So G.H. Thursby mentions the huge impact of this poster in his book, Hindu-Muslim Relations in British India. He writes, several days after its appearance, an Urdu poster was distributed in Amritsar, which called the attention of Muslims to what were apparently the particularly objectionable portions of the article. The Mirza, or leader of the Ahmadiyya Muslim sect of Qadian, was the attributed source of the poster, which provoked protest meetings against the article and led to noticeable unrest among many of the Muslims of the city. Therefore, early in June, a Muslim deputy superintendent of police brought the article to the attention of the local government, and this resulted in proscription of the May issue of the journal Vardaman-e-Risala under Section 99A of the CRPC. And then on June 6, prosecution under 153A of the IPC was undertaken by the government. Both Gyan Chand Pathak, who was the acknowledged editor, printer, and publisher of Vardaman Journal, and Devi Sharan Sharma, who was the alleged author of Sair-e-Dozakh, were arrested, and the Amritsar district magistrate began to hear testimony within days of their arrest. Lawyer Balraj Puri, who was representing the accused in the Risala Vardaman case, contended that the Qadiani posts that referred to the offending article in Risala Vardaman were the real culprit. And Puri went on to distinguish between contempt and hatred and argued that each of the witnesses produced by the prosecution had felt indignation or shock or contempt at the article, but had not felt hatred towards the community or towards the people or this. So it was shocking, but it was not inciting hatred or disharmony. The lawyer Puri argued that although Justice Dalal had chosen to place himself in the shoes of an ordinary man, he had been expected to decide the case as a judge and not as an ordinary man. Puri alluded to earlier publications that had criticized Dayanand Saraswati, the founder of the Arya Samaj, but whose authors had not been prosecuted. The position was reduced to this, as mentioned by the lawyer Balraj Puri, that should it so be taken that whoever happened to shout the louder was to be heard. Curiously, none of the leading Hindus that the defense summoned were ultimately produced in court. And this silence on the Hindu community and non-cooperation by not turning up in court in support of, the defense was seen as a tacit approval of the Hindus being against such publications, and the Muslim communities viewed it as such. As the weakness of the Hindu community, the cowardliness of the Hindu community, as such, this silence was giving a lot of, wrong signals to each and every person who was associated with such kind of cases. Having heard the case thoroughly, Justice Broadway found both the author and the publisher guilty, and therefore charges were brought against them, and they were sentenced with imprisonment, and the case was concluded on 6th August 1927. Now, Balraj Puri very clearly makes a mention that just as in the Rangila Rasool case, the publications similar to the other scurrilous Muslim publications against the Hindus, they were being published and they were being circulated amongst the readership of the very community that it was published for the readership. The Hindus were publishing for the Hindu readership, and the Muslims were publishing for their Muslim readership. And this was basically to kind of thwart the others' conversion processes. And apart from that, it was also something which should be linked to the immediate result of some public order issue or some communal issue. But the lawyer Balraj Puri here mentioned that the publication was being read and it didn't come to the public notice or was not caused to be seen as inflammatory until these posters were put up. And like Gandhi, when he complained about it and attributed motives and intentions to these publications. And so all these kind of opinions in the form of these posters and all that led to this hatred and incitement, not the publication itself. So he kind of gave a precursor to what was later debated in the lawmaking select committee or 295A, that there should be a link between the writing or the publication or the matter and concern and immediate outbreak of public order situation or communal situation. However, in this case, with Chitra Jeevan and Risala Vartaman, the authors and the editors, publishers were held guilty and were given the sentences according to 153A. And in August 1927, the case was concluded. Now, this was sufficient test cases for British governor of undivided Punjab, Haley, to kind of overturn the Justice Dalip Singh judgment and to make sure it doesn't stand the test of time. And so now the stage was set for making a new law, because 153A was found deficient. And so some amendment was to be made to the law as per the suggestion of Justice Dalip Singh, that 297 should be added with something more to deal with such, scurrilous writings. And so these two served as the test cases. Now, amongst all of this, the call for resignation of Justice Dalip Singh, who had acquitted Rajpal, had caught a lot of steam. And The Muslim, of course, had condemned the judgment. And so the government decided to prosecute the editor and printer of Muslim Outlook for contempt of court. And the editor and printer D.S. Bukhari was awarded a sentence of contempt of court. And this sentence also stung some Muslims into recognizing that while the dignity of the court could be protected, the dignity of the Prophet could not. And then you also had Lahore's chief Muslim publicist, Maulana Zafar Ali Khan, urging Muslims to continue to raise their just demands in this volatile situation, as it might get passed, which included 52% of representation in the legislature, universities and services in the Punjab, but in provinces where Muslims formed a minority as well. They should not demand more than their due. The raising of such material concerns in an increasingly emotionally charged atmosphere was rare. Then we see the murder of Mashe Rajpal by commoner, a carpenter, Ilmuddin, and who is then henceforth revered as Ghazi in Pakistan. So by this time, after his acquittal, Mashe Rajpal was a marked man, and in 1927, the same year he was acquitted, there were 2 unsuccessful attempts on his life. April 6th, 1929, a 19-year-old carpenter named Ilmuddin stabbed Mashe Rajpal on his chest 8 times while he was seated in the outer veranda of his shop. And this led to the death of Mashe Rajpal. Now, it's very interesting to know that Mashe Rajpal's killer was represented in court by one of the topmost lawyers of that time, Muhammad Ali Jinnah, who argued for his innocence. So definitely, a carpenter did not have access to such a huge, prominent political and legal, personality. And so there was definitely the community behind this, and Muhammad Ali Jinnah's own, motivations, political motivations, and other motivations. And at the funeral procession, the Imam of Wazir Khan Masjid, Imam Muhammad Shamsuddin, led the janaza, which was attended by millions of Muslims. Maulana Zafar Ali Khan said ahead of the burial that, alas, if only I had managed to attain blessed status. The famed poet Allama Iqbal proposed a separate Muslim state in 1930 also. He carried the funeral bier along its final journey, and as Iqbal placed the body of Ilmuddin into the grave, he tearfully declared that this uneducated young man has surpassed us, the educated ones. May our lives be sacrificed for you, O Rasulullah. Punjab politician and a victim of blasphemy assassination himself, Salman Taseer's own father, the left-wing poet Muhammad Din Taseer, was among those also who attended this funeral procession. And it is interesting to note the reactions of the Muslim community to such crimes of murder, and they hailed him as Ghazi and protector of the religion. On the other hand, the Hindu silence during the trials and throughout the proceedings and the death, the killings, etc. of all these Arya Samajists, the deafening silence was something which was very strange. And the reactions from both the communities towards this was interesting to see. There is a mausoleum in Lahore's Miani Sahib graveyard which celebrates the sacrifice of Ghazi Ilmuddin Shaheed, the holy warrior martyred to avenge the blasphemy against Prophet Muhammad. After partition, Mashe Rajpal's family moved to Delhi, from where Rajpal and Sons continues to operate today. And almost 70 years after his death, he was awarded the first International Freedom to Publish Award by then Deputy PM L.K. Advani. Now, the carpenter Ilmuddin, who had killed Mashe Rajpal and was hailed as a Ghazi or protector of the religion and a true defender of Islam and the Prophet. One should be very, shocked to understand what was his real motives behind the murder. And for decades, this discomfiting Punjab police diary, recorded by police inspectors Saeed Ahmad Shah, Sardar Pratap Singh, and Johar Lal, has lain inside the Punjab archives in Lahore and is also available online. It is hard to imagine that none of Ilmuddin's many hagiographers discovered this document, the only legal document, one in which the illiterate blasphemy murderer's own voice confession may be heard. So little in Ilmuddin's confession casts him as being engaged with great communal currents unleashed after Rangila Rasool publication. An incendiary tract attacking the Prophet's sexual morality was published in 1924. He says that Ilmuddin in his confession says that 5 months before communal riots broke out at Lahore in 1927, in the wake of her being acquitted by the High Court, Ilmuddin said he had left for Multan to help his father make furniture for a hospital. And then after a 1 week break in Lahore, he left again, this time to work in Kohat. Then he returns to Lahore in 1928, late 1928. And in his confession, he says that he had long known of the blasphemy issue and even encountered Rajpal personally, but wasn't particularly interested or communally charged. And during 1927 visit to Lahore, he also recalled hearing that a Hindu shopkeeper of Anarkali had published a book called Rangila Rasool against the Holy Prophet, for which he was prosecuted but acquitted. However, this information too did not seem to impel Ilmuddin to act. And Ilmuddin says that he saw Mahasaya Rajpal several times again on the evening of Shab-e-Barat in 1928, on the way to a visit to Lahore Zoo, also when he visited the studio of Girdhari Lal, together with Deen Muhammad, his friend, to be photographed. The thought of violence never seemed to have crossed his mind. So according to his confessional account, instead, his whole account centered on his friendly terms with Sadiq Kasab, nicknamed Haji, an adolescent boy living in Lahore's Siranwali Bazaar. A few days before Eid, Haji stopped speaking to Ilmuddin and also refused to accompany him to the famous fair of Chiragan, held to mark the death anniversary of Punjabi poet Sufi Shah Hussain. To his dismay, Ghulam Nabi, another carpenter living in Siranwala, claimed that he had committed sodomy on Haji. And the next day, Ilmuddin said that he confronted both Haji and Ghulam Nabi at a pan shop owned by his friend Deen Muhammad. But a fight broke out and Ilmuddin slapped Ghulam Nabi. And after this, Haji told me that he could not bear my sight and he did not want to speak with me. And this shocked me very much, and I felt myself tired of the world. So in the course of the Tonga ride home, Ilmuddin told his painter friend, Jatta, that he was considering killing himself and Haji, as he found no reason for him to live. Although Jatta backed the idea of killing Haji, he observed that people would say I had destroyed my life for the sake of a villain. That same night when I went home, I felt tired of life, he told the police. I thought that if I were to put my end to life, I should better do it to vindicate the Holy Prophet's honor by doing away with the said Hindu, that is Mahasaya Rajpal, and thus get martyrdom. And this was supposedly done, in my opinion, to make Haji, his dear friend, repent and feel, sad at the loss of Ilmuddin, who would be known as a great martyr of Islam. In the morning, Ilmuddin went to the barber for a shave, washed and drank a glass of sattu for breakfast. He met Deen Muhammad and Haji in the bazaar and told them that he was going to Kohat and that they should excuse him if anything bad had been spoken by him. He then proceeds to kill Mahasaya Rajpal in the office of his printing house. And the source I have given at the bottom. Now we move to in the socio-political and the religious context of this whole background of the Rangila Rasool case and the developments and the hasty need to bring about a law to deal with such blasphemous acts was taken up by the British. So I have given you a background of the socio-religio-political background to this and what all was happening and how politics, religion, and society was, on very tight kind of situation in a very and in a very heightened and emotionally charged kind of a scenario that was being played out. And so all this together with the freedom movement and it was a very tense situation at that time to live in, and very heightened kind of environment all around. And therefore, the British wanted to hastily stop these kind of communally charged, publications and the Muslims threatening with Sharia and executing the, Sharia-like punishments to the offenders of Islam and the Prophet as per the Sharia law. So they were the laws. These people were being prosecuted. They were being fined, but still Sharia-like killings punishments were being meted out like an extra legal, extrajudicial kind of, by the Qazis and the Maulanas and the Muslim community on their own. So Sharia was already being practiced. And so they found a necessity to add another section to the IPC and quickly amended to deal with such kind of activities to put a stop to it so that they could focus on some other issues. Now, all these riots happening everywhere and the ensuing movement to amend the Indian Penal Code would mark not only the emergence of a new effective urban Muslim public community, it would also raise critical questions on the relationship between law, the state, and society. Between leading Muslim citizens and the governor continued to preach violence and threatened to overwhelm the law and order machinery of the government. The Deputy Commissioner of Lahore prohibited holding of public meetings under Section 144 of the IPC. This in turn led to a civil disobedience campaign of defiance headed by the Khilafatists in Lahore. And so they gave a time of around 7 days to the government to, kind of carry out some consultations with the government and see if they can come to a consensus or a understanding, or basically giving into the demands of the Khilafatists. The weeks following the Vartaman judgment saw the British government in India preparing hastily for an amendment to the IPC. Their intervention, neutral in their eyes, was the need of the hour. Law, as we will see, was rendered accessible, amenable to pressure. It was a reflection of society, not the staging of state sovereignty and legitimacy. So the law started to reflect society and give in to its unreasonable demands instead of applying the law and applying its sovereignty in the matters of legal decisions. It is worth recalling that the Legislative Assembly in 1927 was a different political space from the legislative councils of earlier years following the Morley, Minto, and Montfort reforms of 1909 and 1919. The Legislative Assembly was now a space that included some Indians, a few of whom were elected, albeit under a limited franchise. So this Assembly's independent assessment of Hindu-Muslim relations and the role of the state would become apparent in the course of these debates, which we will see. And 1927 was also a very different political time, and the social-religious environment also was highly charged. So by the 1920s, colonial law was responding to the pressures of multiple constituencies. Religious communities, as well as particular occupations such as the press, academia, and lawmakers were taking crucial responsibility for a broader business of governing a diverse country. To begin with, the Home Member J. Crerar proposed the bill for this dealing with these blasphemous kind of issues as a measure to make a scurrilous attack upon religion as the substantive matter, so that it was no longer necessary to have to prove that feelings of enmity or hatred between different classes had arisen out of the publication in question.
for it to come under the law, the first and most enduring set of objections to this proposal was in fact raised by members from across the country. Abdul Hai and Lajpat Rai from Punjab, M.A. Jinnah and D.V. Belvi of Bombay, Hari Singh Gaur from the central provinces, and P.A.K. Sherwani from the United Provinces, all complained the scope of the bill was too wide. So the Punjabi Hindu representative Lajpat Rai thought the bill retrograde, although he considered it to be a necessity under the prevailing emergency. He pointed out that social reform was closely tied with the religious reform. Foregrounding the problem of intention, Rai requested an explanation or change in language so that bona fide criticism, historical research, and all that leads to the interpretation of religious texts in such a way as to lead to progressive reform in social matters will not be affected. M.A. Jinnah too felt that the select committee to which the bill would be referred should strive to secure this very important and fundamental principle that those who are engaged in history and those who are engaged in the ascertainment of truth and those who are engaged in bona fide and honest criticism of a religion shall be protected. And Jinnah added that on this matter, there appeared to be no difference of opinion between the government and those seated on his side of the house. So you see a very important distinction was proposed by the members of the select committee and also by Jinnah and, Lala Lajpat Rai and others, that this law should not be set to penalize everybody who, talks about religious leaders and discusses them in historical works and in assertment of truth, and those who are engaged in bona fide and honest criticism of a religion. So all these things were made sure in this select committee that were put across, and a fine distinction is made amongst malicious intent, scurrilous reporting, and bona fide historical and critical research and honest criticism that should be protected as a matter of free speech. Also in agreement with the principle of the bill was Mr. S. Srinivas Iyengar, leader of the Swarajists in the House, who reminded this party that members could vote according to their individual conscience on the bill. Iyengar also touched on the larger question of what constituted religion when he argued that religion had become but a plaything, but a toy, and you use it for the purpose of your secular ambitions and for your secular quarrels and rivalries. And but what precisely was the bill supposed to do? The key to confirming guilt under the new law would have to be around the intention with which an author wrote about religious beliefs. So Hari Singh Gaur pointed out that the penal code already has 3 other classes of cases dealing with defamation of the state, also known as sedition, of a class and of a person. Was this new law simply about defamation of a new category, that of religion? If that was the case, then perhaps it should be called the law of blasphemy. He also suggested that intention had been analyzed in 2 distinct ways. One, as an express intention, when nothing is said to be done intentionally, which is not done with that intention. And 2, a presumed intention whereby every man is presumed to intend the natural consequences of his act. So given the difficulties of the use of the term intentionally, Gaur suggested its replacement with whoever with intent. This founder of Vice Chancellor of Delhi University also spoke strongly for the historical writings of scientific character. And writings even of a polemical character are not all punishable and should not be punishable under the new clause or under section 153A of the IPC. Because by doing so, you would be gagging the expression of free discussion. And I'm perfectly certain that it is the object of the legislature here that there must be the maximum of personal liberty given to the people of this country to express their views without the fear that they would be prosecuted merely for an expression of opinion, that their intention may be to improve other religions, or it may be a mere matter of social reform, or their intention may be merely to publish the views which are the results of prolonged research. So you see, a very clear distinction was put across by many members of the select committee that there should be a protection given to such writings and speeches which are of scientific character, which are in the matter of improving other religions, and which are matters of prolonged research, and they are, of should not be punishable, because then it would be gaining free and freedom of expression. And so that should be the maximum. And they should not be prosecuted merely for an expression of opinion that their intention may be to present the truth based on the research and to reform and improve other religions. So Pandit Madan Mohan Malviya, a Sanatanist from Allahabad and Jhansi division, along with several other members, opposed the motion for the circulation of the bill amongst the public, as they believed that it would delay a measure that was desperately needed. And so you can see that a lot of these very important objections and exceptions to this new law was submitted by the select committee members. And so one very important suggestion made by from Bombay, he asked the home member that regard these manias as I do from the point of view of an Indian and treat them as a temporary phenomenon. He hoped that the government would deal with the real cause of this problem and bring in or allow a non-official member to introduce a measure that would make sure that each conversion is really a psychological change of faith and not brought about or in an atmosphere of fraud, deception, promises, threats, or even political considerations. Jayakar thought that the surge in obnoxious publications attacking one or the other community was directly related to the rival movements for conversion that were then in vogue, and this kind of legislation would not be a cure. It was merely an expedient measure which should be temporary and removed later, because it can seek to cause more harm than cause relief or solution. He rather put across this point that in the meanwhile that this law is in effect, the government should do its duty of removing the real cause of this, which is of course forced conversions and a lot of other such communal disharmony issues that were coming up from time to time. So also there was a lot of haste in all this, and it was criticized by many such select committee members. And this was something which was also taken up quite some time, sometimes in this meetings. So after section 295 of the IPC, the following section shall be inserted, namely 295A, that whoever with deliberate and malicious intention of outraging the religious feelings of any class of His Majesty's subjects by words either spoken or written, or by visible representations, insults or attempts to insult the religion or the religious beliefs of that class, shall be punished with imprisonment of either description for a term which may extend to 2 years, or with fine, or with both. So the words deliberate and malicious were inserted to ensure that the section would be both comprehensive and at the same time of not too wide an application. And the bill also came with 3 important minutes of dissent. The first was by A. Rangaswamy Iyengar, Arthur Moore, K.C. Roy, N.C. Chandar, and N.C. Kelkar, opined that the bill would not achieve its purpose of deterring people from scurrilous attacks upon religion. The bill was deemed to be regrettable concession to intolerance. It might even increase fanaticism because it creates a new offense which is based on religion. Dissenting members thought the existing laws were adequate to deal with the breach of peace. And the third minute by N.C. Kelkar thought that an exception should be added to this section, which said that it would not be an offense under this section to criticize the principles, doctrines, or tenets or observances of any religion with a view to investigate truth or improve the condition of human society or to promote social and religious reform. Such an exception may seem superfluous, but would make things quite clear and be a good guide to the judge. So these were some very well reasoned, and very, something which we see happening today. And these were already feared by these certain wise and well-meaning select committee members, that these exceptions and these things should be taken care of. However, vaguely worded, 295A was taken out, and there were no exceptions or anything added as they were mentioned here. And so we have this, which can be interpreted in many manners by the, courts in the future, and we have seen that happening, and we will discuss that. And also, there were a lot of, issues presented by the other select committee members, where some felt that the bill did not provide adequate safeguards to the honest publisher and honest printer. And so these kind of, objections that were there should be taken into consideration by our judiciary today and our government today, and understand that this law was made at a time that was, it was expedient to carry this out, and it was done in haste. And there were a lot of, fears that were represented by the members and good suggestions that were given. And it is the duty of the judiciary and the government to ensure that these are put into practice. And if not a repeal of 295A, then at least a relook at it, and exceptions added to it or conditions added to it. And it should be enforced also via the judiciary and supported by one and all, because this can swing both ways on both communities. And so therefore the secular government should not be swayed by consequences, and in fact the content should be the deciding factor. And as a secular government, which community is more sensitive or more fanatical should not decide the enforcement of the law. So the consequence should not be the judge, and the law should be equally applicable to both communities, despite the fanaticism, which should be curbed and by state actions. And in a secular and democratic country, the law has to be applicable to all equally, not on the basis of the reaction or fanaticism or the consequences, but the content. So that is how the Section 295A comes about. And this is all taken from the source Beyond the Communal 1920s, The Problem of Intention, Legislative Pragmatism, and the Making of Section 295A of the Indian Penal Code, authored by Neeti Nair. Now it is very interesting to see that the Sharia continued even after Section 295A was enacted, and murders of the same nature as Mahasaya Rajpal and the others, Lekram, etc. Even after Section 295 was enacted. And in 1931, bookshop owner and publisher Bholanath Sen was stabbed in his chest by Amir Ahmad and Abdullah Khan. And they said that he had committed blasphemy as he had authored and published a Bengali book called Prachin Kahani for School Boys, which had a pictorial depiction of Prophet Muhammad in conversation with Angel Gabriel, which is forbidden in Islam. And so again, this was brought into focus by religious leaders in their speeches. And of course, these murders were inspired by Ilmuddin and the kind of praises that were attributed on him. They also were motivated by the same. They were given the death sentence, but the only Muslim of the bench opined against this death penalty. I've given the source for the same. Also, in the same following years, similar killings were still happening despite 295A. And this fear was also put across by one of the select committee members, as I just mentioned in the previous slides, that this would give rise to more fanaticism. And this will not help in solving the problem. Rather, it might exacerbate this issue, because now it will religious, offense will become a law, and given the sanction of law that it is an offense and it is wrong. So Nathuram Ramal Sharma was murdered by Abdul Qayyum in September 1934, and Sharma was stabbed to death in the court of the Judicial Commissioner of Sindh, where he was seated awaiting the hearing of his appeal against the conviction under Section 195A for the publication of a pamphlet on the history of Islam. Then Khanna, the secretary of the Hindu Sabha, was severely assaulted in 1938 by Mohammedans after a session of the Hindu Mahasabha was held in Ahmedabad, and he very narrowly escaped death. Now we come to independent India, when the constitution was made, or in the process of being, the articles being added to it. So it was not very long after the adoption of the constitution when this section was challenged on grounds of infringement to freedom of speech. Although before coming to that, in the year 1951, the First Amendment was passed and freedom of speech became a restricted right from an absolute right under the lens of reasonable restriction, which is, of course, this 295A and sedition and other such things. There was no specific definition of what exactly was reasonable restriction. The definition in itself was very broad and has never been challenged. So Dr. Shama Prasad Mukherjee also had various contentions with the implementation of this term. And he was very amendment, the First Amendment, because he believed that this can be misused very easily in the future. And in a way, he was right in saying so. Then comes the constitutional judgment of Ramji Lal Modi versus the state of UP. Is the case where the constitutionality of this section 295 was challenged. There was a publisher of a magazine named Gau Rakshak in the state of UP, which was dedicated to the cause of cow protection. He ended up writing a certain article on certain practices of a section of the society. The article criticized the Muslim community or certain aspects of attitude from the Muslim community, which resulted in his prosecution, and he was even convicted under this section in the Sessions Court. Ramji Modi then appeals to the judgment in the High Court and in the Supreme Court, and he gets no relief. Hence, he ended filing a writ petition under Article 32 of the Constitution, challenging this Section 295A as an infringement to Article 19 of the Constitution, that is freedom of speech and expression. The petitioner submits the argument that Section 295A fails to make a distinction between criticism of religion, which causes public disorder, and criticism of religion that does not cause public disorder. So the chain of events, or the immediate effect of such criticism was not defined. That did this lead immediately with no intermingling factors, like we saw the poster being published for Risale Vartaman, leading to public outrage, or Gandhi publishing in Young India, writing about his opinions, leading to outrage against Rangila Rasool pamphlet. And so external engineered circumstances should not be the basis of punishing somebody who does a criticism of religion. That was what was the question of Ramji Modi. The petitioner highlighted that in the year 1951, Article 19(2) was amended, and the amended definition of reasonable restriction was, in the interest of security of the state, friendly relations with foreign states, public order, decency or morality, or in the relation to contempt of court, defamation or incitement to an offense. The petitioner hence stated that Section 295A is covered under the chapter Offences Against Religion and not Offences Against Public Tranquility under the Indian Penal Code. Hence, the petitioner concluded that the impugned section does not enjoy the protection of Article 19, Clause 2, because it is a law that is imposing restriction on religion and is not a law that cover under the ambit of public tranquility. This primarily suggests that there is no necessarily any relationship between offenses against religion and its impact on public order. The court, however, focused on the broader aspect of Article 19, Clause 2, and believed that if a provision is not working directly to maintain public order and is being used under a broader sense to work in the interest of maintaining public order, it should be still considered as constitutional. So the justification for that decision was that the statute only punishes aggravated forms of insult to religion perpetrated with deliberate and malicious intention. However, the words deliberate and malicious were inserted to ensure that the section would be both comprehensive and at the same time of not too wide an application. The petition was then dismissed and the accused had to serve his commuted sentence. This judgment then became the bedrock of this legislation as it approved the existence and constitutionality of this legislation, which was 295A and Article 19, Clause 2 of reasonable restrictions. And this followed a series of cases that then invited a restriction or ban to literature, books, commentaries, etc. So far, flinching results of such a judgment. However, the important question that was supposed to be answered under this case was whether there is any connection between the speech and literature in order to maintain public order, whether the speech directly or indirectly vitiates public order. It becomes very imperative, as in other provisions related to hate speeches, the question of public order is very relevant. There is a dire need for a set of comprehensive guidelines on the implementation of this section by the Supreme Court in order to clarify the ambit of Section 295A with respect to free speech expressed by artists, storytellers, historians, etc. The provision for all practical purposes is hampering any academic discussion on historical facts, even if the author has no malicious intent. So this is a very important point to note. Although one could refer to the judgment given by the Kolkata High Court to get a better idea of the implementation of this legislation and the guide provided, in this judgment, the court came up with an excellent test for implementation of this particular section in the case of Sujato Bhadra versus State of West Bengal. The matter was filed against author Taslima Nasreen for her book Lajja, where she mentioned atrocities done on Hindus in Bangladesh post the Babri Masjid demolition. The book had no objections as she backed her claims with facts, history, and reality. So the judgment of the court categorically said that insult or attempt to insult the religion or religious beliefs, when made with an intention which must be deliberate or malicious of outraging the religious feeling of a class of India, only then this section will be attracted. And the court then goes on to mention that to outrage religious feeling or insult to religious belief is made unwittingly or carelessly without deliberate malicious intention. The same would not come within the purview of Section 295A. The expression deliberate and malicious is indicative of the intention of legislature and hence should be both in the form of deliberately malicious. If it is made knowingly, but with an intention oriented by securing or stimulating the welfare of the society or emancipating the women, in such case, the outrage of religious susceptibilities or beliefs, even though intentional, can't be termed as deliberate and malicious. Very important to note. So the objective, if not to scrap. So in order to establish the ingredient of 295A to be applicable in the case, it is to be established that the author had the requisite mens rea or intention that was deliberate and malicious to outrage the religious feelings of a class of citizens of India, and to attempt to insult the religion and intent should be deliberately and malicious for that class of citizens. So the objective, if not to scrap 295A IPC, if that is too difficult to scrap it completely, can be of at least providing a better and comprehensive clarification on the implementation of this section and not let loose to be interpreted differently by different judges and courts, as we have seen in different judgments of similar cases. So the second issue is the broad and unchallenged scope of Article 19, Clause 2. The rationale that a literature or speech can be restricted even in the interest of maintaining public order, rather than a speech or literature that could directly vitiate public order, is something that needs a reconsideration. So, believing that it could lead and it actually directly vitiating public order is something that also needs to be looked upon. So in the judgment of Shreya Singhal versus Union of India, the Supreme Court made the distinction among discussion, advocacy, and incitement. And the first two are at the heart of Article 19, Clause 1A. And as soon as discussion or advocacy leads to incitement, Article 19, Clause 1B is applicable. So this is a very fruitful litmus test of this Section 295 that should be used. The provisions of blasphemy shall only be implemented when there is an action by an individual which leads to violence or public disorder. The present implementation of the section by all means is making all academic discussions based on religion, history, and culture also very, very difficult. The way it is being enforced and implemented currently. Divorce of all these important judgments and the discussions in the select committee, and also by various other wise and learned men from both the communities who wanted this to be considered on a more deeper level. It is very important for us to understand that an educated and a modern democratic society shall have the leverage and the liberty to have any forms of academic discussions on any subject. The same shall under no circumstance be restricted unreasonably due to ambiguity in the implementation of the law or political expediency. Now let's take a look at blasphemy laws around the world and how they are being abolished. So blasphemy started off as a Christian law, which originated in Greece in 325 AD. Between the conflicts between the Christians and the Jews. A prosecution for blasphemy in the USA would be a violation of the US Constitution, and no blasphemy laws exist at the federal level. The common law offenses of blasphemy and blasphemous libel were formally abolished in England and Wales in 2008 and in Scotland in 2021. Blasphemy laws are most common in majority Muslim countries of Middle East, Africa, and in pockets of Poland and Italy, where Islam is in the majority or almost in the majority. Iceland, Sweden, Norway, Spain, and Malta have scrapped their blasphemy laws. Denmark has blasphemy laws, but have not enforced them in decades for obvious reasons. In August 2018, Pakistan's new Prime Minister Imran Khan pledged to revive a campaign to impose global blasphemy laws at the UN. A previous attempt, spearheaded by the Organization of Islamic Cooperation, ended in failure in 2011. The United Nations condemns nations in which blasphemy laws are in place, as it declares countries with blasphemy laws in any form that have signed the ICCPR are in breach of their obligations to it, as it impedes the freedom of expression tantamount to draconian nature. And also recently we saw that a law to ban Islamophobia was also not passed by the Congress in America. So IPC section 295, as we see it today, is mostly used as a tool of harassment. It is a cognizable offense. The section invites application of section 41 of the CRPC, which permits the police to arrest any person without a magistrate sanction at the mere instance of an FIR, or at the complaint being deemed as the police officer merely reasonable according to the police officer. The allegations seem to be merely reasonable also, and the FIR is lodged, and the police officer has the duty to see whether it is reasonable or not. But in today's atmosphere, that doesn't seem to be happening. Further, the criminality attached to the section allows for a complaint to be registered at any police station across the nation, paired with the fact that a suit can be filed at any of these 600 district courts across the nation. Its prima facie seems facilitative of abuse and harassment. In addition to it being used as a tool for harassment, 295A prima facie seems violative of the fundamental right to freedom of speech provided by Article 19, Clause 1A. And it is obviously due to the vague terminology it employs. The IPC contains an entire chapter upon offenses related to religion, which includes 295A. But however, it falls short of defining the terms religion or religious, even though they appear no less than 19 times in it. And similarly, the Constitution fails to provide a conclusive definition of these terms. Now, the Supreme Court, rather than providing clarity upon the issue, further muddles the waters vis-a-vis verdicts such as the one delivered in SP Mittal versus Union of India case, where a 7-judge constitutional bench held that religion to be a term which cannot be defined and further enhances amidst the ambiguity surrounding it by stating it to be a matter of belief and doctrine concerning the human spirit expressed in the form of ritual and worship. The section's susceptibility to misuse is often justified by critics, citing the communally volatile nature of Indian society, which necessitates criminalization of anything which may be deemed to be remotely religious. Considering the recent jurisprudential developments in many cases and the blasphemy laws being abolished world over, and the United Nations also not supporting countries having blasphemy laws, Section 295A displays its constitutional untenability in today's times. So it tries to curb legitimate criticism of anything which can be remotely related to religion. And thus, it is inherently personal and malleable to an individual's will, demonstrates it being bad in law. And so the defense of Section 295A is afforded further veracity in light of the fundamental rights pertaining to religious freedom enshrined in Articles 25 to 28 of the Constitution. State sanction is further invited due to the Nehruvian model of secularism followed by India, which puts all religions at an equal pedestal and allows for institutional protection for essential religious practices as defined by Ismail Faruqi versus Union of India. This departure from the classical French model of secularism, which calls for a strict delineation between the church and the state, allows for the perpetuation of policy and laws along religious lines, availing political parties avenues to pander to their vote banks and appease communities by restraining anything which may be counterintuitive to their beliefs, no matter how regressive. Restrictions upon free speech necessarily have to be reasonable. And so with public order being invoked as a protection to Section 295A in the Ramji Lal verdict, it is held that any law penalizing which merely had the tendency to disrupt public order was in line with the reasonable restrictions in Article 19, Clause 2. This tendency could be constructed in manner to invite sanction on anything which may even hint at being the inception of a public disorder without considering factors such as a time difference or nexus with the chain of events, a holding which is extremely problematic and needs to be clarified or overturned. So within 3 years of the Ramji Lal Modi judgment, the Supreme Court adopted a new legal position with the 5-judge pronouncement in the Superintendent, Central Prison Fatehgarh versus Ram Manohar Lohia. The bench comprising of judges, none of whom featured on the Ramji Lal Modi bench, necessitated the need for approximate link between the exercise of speech and public disorder being created. The verdict explicitly admonished the fanciful connection between the impugned act and public order, clearly in countenance with the tendency propounded in the judgment of Ramji Lal Modi. This line of argumentation, interestingly, was refuted by the bench in Ramji Lal Modi. So this is the developments so reaffirming the Supreme Court of the United States of America devised Brandenburg test, our Supreme Court held that criminalization of speech is only permitted if it incites imminent lawless actions. So these are some very important jurisprudential, kind of developments that have happened and which prove the constitutional untenability of 295A. So one has to imagine three concentric circles, the largest representing law, the next representing public order, and the smallest representing the security of state. An act may affect law and order, but not public order. So that is the kind of, understanding that one should have, that it can have a law and order situation between, certain communities or individuals, and it has to be the response of the state and the law and order, administration to take stock of it and to stop it. But however, public order disruption is something of a graver offense, and that needs to be then punished. So this is so in the light of the jurisprudential developments as well as the academic critique of the aforementioned section, Section 295A necessarily displays its constitutional untenability. Further, the chilling effect it has upon any legitimate criticism of anything which can be remotely related to religion, a term yet to be given a definitive description, sentiments, a term which is inherently personal and malleable to an individual's will, demonstrates it being bad in law, and so it needs some consideration, if not complete doing away with it. So after all this, I'm sure you would have understood what are the possible solutions to it and what the judiciary and the state and the society as a whole and needs to do. But some possible solutions, to put it down in bullet points. This is not an exhaustive list. It is something that is put down in as short as possible. The court should also prosecute the initial offender in whose provocation counter remarks are made, and also prosecute public property destroyers who threaten with sartan se juda or such Shariat-laden threats, even though there are the courts and the law that are there to deal with it. And those who hold agitations or carry out riots. The court should provide protection to the person charged of blasphemy and receiving death threats. Like you saw Maharaja Rajpal being attacked twice, the attack on his life. Then you have the Kamlesh Tiwari case, where he was put under preventive detention and there were attacks on his life, and the state failed to protect. When there are such, death threats coming from all over the place, the recent Nupur Sharma case is one example. Swift and severe prosecution in public order issues, if taken up by the state, will have a deterrent in the community and change the fanatical conditioning. It is the responsibility of the state that no community has a fanatical outlook and to make sure that such incidents do not take place, ensuring peaceful coexistence. It should not be pushed onto individuals only of a particular community or an entire community as their responsibility to maintain communal harmony alone by curbing their free speech just because they have an infinite threshold of insults to their community and religion. And the state should adopt different standards of application of law to different communities on the basis of their fanatic nature and actions. The rule of law, criminal law, applies to all equally, and that should be upheld at all costs in a secular and democratic states. With that, I end my presentation. I hope it was, interesting for all of you, and it gave certain new insights and possible solutions. And I hope this is heard by the relevant authorities, the state, the judiciary, and the people, and to make them aware of their duties, responsibilities, and their outlook towards this. And we get to see a much better, solution-laden society that we live in with regards to such issues in the future. And there is actual harmony and the real causes are taken stock of. So with that, I end my presentation. Thank you for listening. Namaste.